Welcome to the Joint Veterans Endorsement Interviews for Judicial Candidates. We would like to thank our sponsors, Veterans in Politics International, Nevada Veterans Association, Armed Forces Chamber, Judge Jacob Reynolds from Department 29, Judge Mary Perry from Department P. First, let's review the rules and format. The panel members will introduce themselves by stating their names and the organization they represent. Next, each candidate will introduce themselves, indicating the office they are running for and explaining why they are seeking that position. Then we will proceed to the interview portion. Each candidate will have 1 minute to answer each question. When you have 30 seconds remaining, I will notify you, and when your time has expired, I will notify you. You may finish your sentence, but also conclude after that sentence is finished. Panel members will not be permitted to ask follow-up questions. After all panel members have completed their questions, each candidate will be given 1 minute to make a closing statement. Thank you in advance for your professionalism, respect, and participation. Let's begin. Let's have the panel members introduce themselves and the organization they represent, starting with Mr. Walker.
Good afternoon. It's Martin Walker, Nevada Veterans Association.
Good afternoon. Jeffrey Lustig, Veterans in Politics International.
John Brookhagen, Johnny Brew, Veterans in Politics International.
Andre Haynes, Armed Forces Chamber.
J.P. Edwards, Armed Forces Chamber.
Good afternoon.
Candidate Judge, would you please introduce yourself and tell us why you're seeking office in Department 17?
Well, good afternoon. My name is Jennifer Schwartz, and I am your judge in Department 17. I've been your judge in Department 17 since 2023, and since being on the bench, I have earned the reputation of being prepared, respectful, and efficient. My background has been, my life has been really based on the seeking of justice and honor, and it's really, I can focus it on for two different reasons. My family are Holocaust survivors. And although they didn't speak much about the horrors and atrocities that they ever went through, that sense of loss and devastation because of having a government that rules based on evil and not on honor and not on justice and not on fairness. And that has really just held me up to understand that this is what we want in our society, a society that's fair, that's just and honorable. Another aspect is my parents owned a small veterinary practice in North Las Vegas, and growing up at that practice, because of course my parents forced me to go there all the time, I watched individuals who are of lower income and struggling because they love their animals, they love their pets, but they can't afford it. And watching my family do what they can to help these people who any other time they would have to choose money over their pets. And I watched my parents make economic sacrifices so that these people can live with their loved ones. Because, I mean, look, fur babies are our babies. There's no question about it. But watching my family voluntarily choose to take economic losses in order to help other people, that's really what helped encourage me to become the person that I am.
Thank you very much. We're going to start with the first question with panel member Jeff Lustig.
Good afternoon. Thanks for coming in here today. Clark County has one of the largest veterans populations in Nevada, yet some of our veteran cohorts tell us that they routinely face delayed hearings, fragmented diversion programs, and inconsistent access to veteran treatment courts, depending on the department that they may draw for their case. As a judge, what specific actions will you take within the limits of the Nevada Code of Judicial Conduct to ensure veterans receive equal access to justice, timely adjudication, and meaningful alternatives to incarceration rather than justice based on geography or judicial lottery?
Well, I will say this. If someone ends up in my department, they did win the judicial lottery, of course. But look, I said it from the beginning, preparedness, respect, and efficiency. That is my courtroom. And either in a prior life when I was a criminal defense attorney representing individuals, including veterans who came back and needed my assistants, as well as being a judge. As soon as I hear that someone is a judge, or if I review documents and I find out that a veteran, and I review documents and I see that they're a veteran, the first question I ask is this person going to be applied to one of the specialty courts? We have a veterans court. Statistics show our specialty courts are successful. The rate of recidivism for those who complete these specialty courts is low. I'm not saying it's non-existent, of course, but it is low. And I don't control who is or is not accepted into veterans court, but I certainly encourage the participation. And if given that opportunity, I speak to the staffing if there's a question and explain to them why I think that even though they may have concerns about this one individual for one reason or another, this is the person that the program was built for. Also, when I have someone who is a veteran and they are on probation, I tell them, look, you're seeking your treatment through the Veterans Administration, and the paperwork there is kind of insane. I tell them, in order to ensure that you are receiving the treatments that you need to sign all the waivers necessary so that your supervising officer can determine whether you're receiving the treatment that you need, whether you're going about it the proper way, and if we need to tweak something. Because if they hold their papers to their chest, then we have no idea what's going on. So although I'm not trying to invade any more than I would need to as a sentencing judge, a person's personal life. But my job is to help ensure a safe community and ensure that people can be healed. That's part of what we do. And if we have individuals who won't seek the treatment or won't sign the waivers, how are we supposed to know that they're doing what they need to do? I just want people to heal.
All right, and again, thank you for coming. You mentioned your previous role as a public defender, and having previously served in that capacity, advocating for individual constitutional protections. How has your transition to the bench shaped your approach to balancing those protections with the court's responsibility to apply statutory law as enacted?
Well, I will say this. Transitioning to the bench, I've realized I'm no longer an advocate, and there is no question about it. I'm no longer an advocate. I now look at the case in its entirety, from the defendant's perspective, from the prosecution's perspective, from the victim's perspective. And I don't legislate from the bench, and I realize people have different definitions of what that means. The law is the law. Now, if there's ambiguities, of course, it inures to the benefit of the defendant. That's how the law goes. But I ensure that cases are determined based on the facts of the case and the application of the law. I don't make decisions based on who a person is, what their economic background is, their ethnicity, or anything of that regards. It's what are the facts of this particular case, and how does the law apply to that particular case?
Thank you.
Andre Haynes, Armed Forces Chamber. Judge, how would you handle a situation where a major campaign donor appears before you in court?
I'd say hi. How are you doing? I think that, I don't want to say thing. I know that all of the people that support me know that they're supporting me because I am fair and I'm prepared and I'm just. And you may have the big pockets and you may have assisted me in some fashion, but if the law doesn't help your facts, you're not getting I'm not changing my decision. Like I said, and I'm sure I'll say it a few more times during this interview, cases are determined on the facts of the case and the law as it's written. I don't give anyone favors. I also don't take any negatives away from them. I mean, I may have a campaign donor in front of me and they want to win, but I could have someone that was completely antagonistic to my election leading up to it. Doesn't mean I'm going to treat that person any differently than I would any other human being that would walk in front of me or appear in front of me.
J.P. Edwards, Armed Forces Chamber. How familiar are you with the structural and judicial scope of the 17th Court? What distinguishes it from other Nevada district courts?
Well, that's a good question. I mean, what distinguishes my department from other departments? I mean, a number, but the numbers, as we know, mean nothing. But me, I became a judge because I was sick and tired of being sick and tired. We have judges that don't follow the law. I don't know how many times as a practicing attorney I would appear in front of a judge and say, you know what, Ms. Schwartz, I agree with you, but I'm still ruling against you. Well, what's the value of that? What's the point? My case was ruled upon because of what they wanted the results to be versus what they ought to be. And so that's one of the reasons I became a judge, is because we need to have equal application regardless of who you are, where you come from, what side of the aisle you're on or not, what table you sit at. And so that's one of the distinguishing factors that I have. I rule on the case in front of me. I don't rule as a general aside. I don't have a general principle for how all cases should be handled. Each case is handled differently and separately because each case is different and separate.
Martin Walker, Nevada Veterans Association. NRS 5.057 directs consideration of military service during sentencing. NRS 48.015 and 48.025 state that military records and service-related trauma can be admissible as relevant evidence. How do you apply these statutes to your rulings?
Well, I mean, the law is the law, and so I apply the law as it needs to be applied. But when it comes to, for example, documents, I guess I'm going to answer this in an anecdotal way. We have individuals that sign up to be in the military, and they are deployed. And when they're deployed, they are whole, mentally, physically, emotionally. They're deployed, and they don't come back that way. And so I look at whatever I can to find out, is this a person who came back and needs extra assistance because of what they went through? I will review those documents if they're provided to me. And I will ensure that I don't look at a person as for example, a violent person because they may have committed a violent act. They came back, they did what they needed to do. They sacrificed their body, they sacrificed their mind for our country, and I'm not going to just summarily ignore that. So if there's documents that I can review, I will ensure that I review all the documents, and then I will try to direct that individual to a place where they need to be. Again, whether it's Veterans Court, whether it's some kind of inpatient facility that is run through the administration or something like that. But I will always do what I can to review whatever documents are available so that I can make sure that that individual in front of me is given the treatment and the respect and the fairness that they're entitled to.
I would like to ask regarding decorum in the courtroom. I would like to ask regarding decorum in the courtroom. With the post-COVID era that we find ourselves in, there are often times when you have to conduct hearings via video, people that aren't in the courtroom. And then even today, when you see people come to court, they may not be dressed very well. They might be somewhat disorderly. Has there been a time in your career, in your courtroom, when you had to enforce order? What steps have you taken? And why do you feel that decorum in the courtroom is important for seeking equal justice among the cases that you preside over?
The courtroom is supposed to be, a neutral spot. Neutral in the sense that it doesn't matter who you are, you're treated equally, you're treated fairly. Now, I will say this. What your perspective on dressing appropriately may be different than mine. And if someone comes in and they are without a lot of economic means, I don't want them to not come to court because they don't have a suit. They don't have a Sunday best. I don't want them to be discouraged from coming to court because certainly that can result in significant negative effects in their life and their liberties at one point. So, assuming they're not wearing something that is overly offensive, that their body is primarily covered, clothing doesn't bother me because that's not something I take in consideration. That would be taking a superficial perspective on an individual when that's not fair to that person. I don't know where they came from. Decorum, though, I will say the civil side is significantly worse than the criminal side when it comes to decorum, which is always a fascinating experience that civility is lost in the civil world on many occasions. Not all, certainly not all. And when it comes to that, I always remind people, hey, we treat everyone with respect. This is your time. Don't take away from them. They don't interrupt you. You don't interrupt them. sometimes I will interrupt, but I guess that's the power of the bench. But I always try to make sure that they understand we're here to make a record. If you speak over someone, you're not making a record and you're not doing your case justice. So please respect the process, speak when it's your turn, take notes. We all have pens and paper. If they said something you don't like, write it down so that you know that when it's your turn to come back, you can address it. Don't talk over someone. What are you doing? You're not helping yourself and you're just looking like a fool and you're negatively affecting your case, because I'm not there to decide based on the lawyers that are in front of me or a pro se litigant. I'm there on the case. Don't take away from the case. Don't act a fool.
John Brookhagen, Veterans of Politics. Your department handles serious criminal matters in which sentencing discretion is permitted by statute. What factors guide your use of that discretion to ensure that similarly suited individuals receive consistent treatment under the law?
Well, I knew I was going to say it repeatedly, and I think I called it earlier. I look at cases on their individual facts. I don't look at it as who they are, where they come from, what their background is, or anything like that. So, but it goes to victims too. I mean, when I'm looking at cases, I don't look at it just from a defendant's side. I look at it from a victim side. And sometimes we have victims that come in front of us that may come from a background that is completely different than mine, a background I don't understand, or they have a background that I don't necessarily condone, or a lifestyle. But I ensure that every case is handled on the facts of the case, and everyone has the equal footing. And what I mean by that is the ability to communicate to me in a proper way. If it's a victim, I allow the victim to speak, and if it's a defendant, of course. But I always want to ensure that each case is treated individually. I don't group cases. I don't group lawyers or anything like that. I look at the case and I ensure that everyone is treated with the respect and the dignity that they're all entitled to, regardless of who they are. So, I mean, I hope that answers the question. I'm not trying to repeat myself. I feel like I am, and I apologize if I am. But that is one of the things that I think that helps with that's part of where my reputation is built off of. I look at cases individually. I don't look at them as a group.
May I clarify as opposed to follow up? You're showing me how each case is judged individually on their own basic facts, but at the same time, when you have different people from different backgrounds committing the same crime in similar circumstances, the question was more like, how do you keep that sentencing consistent, as opposed to, you do judge everything individually, but at the same time, we do need a standard of justice, and you have the ability to kind of do what you want with sentencing. So how do you guide yourself to keep consistent with the punishments that you give to the accused?
Well, assuming it's not a case that is negotiated between the parties, because I will almost always honor negotiations that are agreed to by the parties, because they know their cases better than I do. But if it's a case where it's all up to me and there's no one making a recommendation to me and I'm just the one that's making a decision, then I look to maintain the consistency. If it's, first-time offender and it's not violent and not mandatory prison, consistently speaking, that person is going to be receiving community supervision, regardless of who they are, where they come from. But if I will say this is hard because I don't really have cases. I haven't seen a case where it's the exact same crime committed by different people with different backgrounds. So the hypothetical is a little difficult in the sense of I can't tell you how I do it, but I always try to. It's an issue of what's fair and what's right and what's just. And if it's someone that comes from a very affluent background and commits some kind of ridiculous little petty theft versus someone who doesn't have an affluent background and commits a petty theft, they're going to receive the same kind of penalty or punishment, likely community supervision. Because again, I don't treat people differently because of where they come from, who their parents may be, or anything like that.
Thank you.
I hope that answers your question.
That's better. Thank you.
Okay.
Andre Haynes, Armed Forces Chamber. Under NRS 200, how do you evaluate sentencing factors in serious felony cases?
Well, I mean, how do I do? I look at the different case. Whatever information I'm provided, I review it. I'm limited. There are a lot of times there are things about cases I don't know about. because it hasn't been brought to my attention. They haven't filed anything. I don't engage in ex parte communication to find out what really happened with this case and what's really going on. So, I look at all the information that I'm provided, and then I try to come at it with what I think is fair and just. So, yes, discretion is up to me. Excuse me, sorry about that. And I take my discretion seriously. But when it comes to, if it's not a mandatory prison case, I guess is what you're referring to, and whether I have discretion of supervision versus prison, I look at the whole case. It's an entirety. Who is the person? What kind of circumstances they come from? What is their background? What's their criminal history? What's their education level? Because education really starts to play a role in it. And if I'm ordering supervision, sometimes I order to go back to school. So it just depends on what's going on with the case. But I take my discretion seriously. I consider as much as I possibly can, because I do. I think that I know that decisions I make, although I may not think that I'm that important, I know that my decisions can affect people and families, communities, things of that nature. So I just try to evaluate the case in its entirety from the defendant's perspective and from the victim's perspective, if there is a victim. We have victimless crimes. So in those cases, I don't consider the victim, of course, but I try to consider the entire case in its entirety. Is that victim out anything? Like monetarily, can that victim be made whole? Things of that nature.
J.P. Edwards, Armed Forces Chamber. Describe a time when you had to make a legally correct decision that was unpopular with clients, colleagues, or the public. How did you handle it?
Well, I have a case in particular. So I don't know if I can talk about the case itself, but I can say generally, I've had cases where the community had a position of what they thought was proper and what's just, when in fact it wasn't even legal what they wanted. And when it came down to it, I followed what was proper and what was legal. Sometimes people want the death penalty on a case that's not even appropriate, and that is an extreme thing, but it's true. People want extraordinary penalties that aren't even legally appropriate. And so in those cases, when I issued my decision, I explained it. Because that's the worst part, is when a judge makes a decision and they just do it without explaining it and without taking the time to say, this is what I'm considering, this is a decision I'm making, and this is why I'm making the decision. Now, whether they listen or not, that's up to them, and I can't change that. But if it's something that I realize it's going to be an emotional reaction from the victims or the public entirely, I explain it so that it can make sense and hope that they listen. There's only so much I can do, but I have to hope that people are listening too.
Martin Walker, Nevada Veterans Association. So earlier, you acknowledged, and thank you for that many times veterans do not return from deployment or whatever as whole. And I think a lot of people forget that. So I appreciate you taking that into account. So knowing that the judge is also the manager of the courtroom operations, how do you handle a veteran who is struggling in the courtroom environment due to hypervigilance or anxiety?
I feel like I'm about to break this microphone. Pardon me, sorry. No, that's just me. I got tangled. I'm a klutz. If I can see someone is about to have a moment, about to have a breakdown, I'll stop. I'll say, Mr. So-and-so or Miss So-and-so, you look like you're having a problem right now. What can we do? Do you want to take a break? Do you need to sit down? Can I get you some water? Do you want me to trail this matter so we can recall it? Do you want to go sit somewhere and kind of gain your composure so that you can come back? Sometimes people think that you need to rush to judgment, and rushing is not necessarily proper. If someone needs time, I give it to them. I'm never going to stop someone who's having some kind of anxiety attack or some kind of PTSD reaction because something triggered them. I'm not going to force them to continue. I'll say, let's take a break. Whether it's a 5-minute break, a 15-minute break, let's come back another day. It's going to be okay. We're going to work together on this.
Jeffrey Lustig, Veterans in Politics International. Clark County's judiciary operates in a uniquely tight ecosystem. Former law partners, campaign donors, political endorsers, law enforcement leadership, and repeat institutional litigants can routinely appear before the same judges and in the same departments. The Nevada Code of Judicial Conduct requires recusal not only for actual bias, but when a judge's impartiality might be reasonably questioned, a standard grounded in public perception and not personal confidence. Describe a situation or a circumstance in which you would be ethically obligated to recuse yourself despite believing you could be fair, and explain how you would place that disclosure on the record in a way that preserves both due process and public trust, particularly when no party has requested recusal.
Well, I can actually give you an example of that. There was a case where it was a DUI death and substantial. And the victims of the case, I did not know them, but I knew their family members. And I knew that even though I'm friends with their family and they know me and they know how I rule, I was fearful that someone would view it as I'm going to rule because of their family, who's going to be in the courtroom. I mean, their family, it was a very supportive family. And I didn't want anyone to think that I was going to rule against the defendant in any way or in favor of the state because my friends were in the gallery. But I knew I could be fair. I knew I could separate the two, but I did not want that perspective to occur. So I said, look, I am friends with the victim's family. And because of that, I do not want there to be an appearance of impropriety. So I'm recusing myself from this case.
John Brookhagen, Veterans in Politics International. Earlier you mentioned a lot of times they'll come to you with a deal, whether it's between the prosecution and a legal defender or a defense attorney. And most of the time you accept that because they know the case better than you do. Do you blindly do that, or do you look into the facts of the case? Because many times these public defenders or the defense attorneys have relationships with the district attorneys. And sometimes I've heard of defendants feeling like they're getting railroaded into taking a plea that they don't think is appropriate, but they don't want to risk going to trial with the further ramifications that might bring. So do you blindly take what they're saying? Because you said almost always, which makes me think that it's not a blanket thing. What goes into that consideration? What do you do to not blindly just accept what they're giving you? And have there been circumstances where they brought a deal to you that you refused to just rubber stamp?
Regardless of what the case is negotiated to, I will always review the case. I will always review the police reports. I will always review whatever documents are provided to me. And there are times when a case is negotiated, and I'll put a little asterisk on my notes saying, make them explain this negotiation. I don't like this. I must be missing something. What am I missing? And I will do that. I will say, hey, you negotiated in this way where this person is essentially going to leave court today without probation, without supervision, without anything, just walk out. These facts bother me. Why does this negotiate this way? And they'll tell me why it negotiated that way. And more often than not, I will understand it. Sometimes it's proof problems. The police report reads that this is an incredibly violent individual, but there's no one that's able to testify to support these charges. There have been a couple occasions where I said, I'm sorry, I can't. One of them I'll never forget because it was, regardless of how the case was negotiated, I was like, I can't. I'm sorry, I can't follow these negotiations. This doesn't seem right. So I will give you an opportunity to either renegotiate the case or I'll let you withdraw the plea and we can go to trial. And then the man went what I would say off the rails, started, asking Jesus to smite my child and stuff like that. So that man was just removed from the courtroom and went to a different judge. So I didn't have to deal with it in the end. But I mean, there are times where I say, look, community safety is my number one priority. And this is an individual who has demonstrated that they cannot be unsupervised. And I don't like this negotiation, and I'm not going to go forward with it. So again, on that one, as soon as he said Jesus needs to smite my child, I was done. But
Thank you.
Andre Haynes, Armed Forces Chamber. If reelected to your position,
you mean when?
I'm sorry.
You mean when reelected?
What are some goals that you have for your department that you'd like to accomplish?
I don't think look, I love what I do. And when I became a judge in 2023, the fact that I started with imposter syndrome and I no longer suffer from that, that's an improvement that I have made. So now the improvements I want to continue to make are continuing to study the law. There are so many different things out there. There are so many decisions that are coming down from our appellate courts. I need to make my main goal is to truly understand more of the cases that are being decided now and why. And primarily the reason for that is this: some of our cases or some of our statutes are not overly clear and they are somewhat vague. But if I can start understanding the few decisions that have been made on an issue, if I have a question, I can make a logical step, the logical next step. If there's no actual answer, I can make it the next logical step. Another goal that I have is to just continue to earn the respect of my peers. And the goal is just to continue improving Department 17. I don't have the aspirations of going on to the appellate courts. My goal is to just make Department 17 the best department that there is. And however I can effectuate that growth is what I'm going to do. It's whether it's my staff, whether it's with me, however it is, my goal is to make Department 17 the best department we have.
J.P. Edwards, Armed Forces Chamber. How would you respond if a high-profile defendant publicly criticizes your courtroom conduct during trial?
Oh, I'd ignore it. I mean, if it's during a trial, my job is not to try to tell people that they're wrong when they're exercising their First Amendment right. I mean, now if it gets to the point where it becomes slanderous, sure, we can deal with that at another point, but ignore it. As a society, we've given people the authority to speak with gumption, even though they know nothing. And I don't think that's ever going to stop. So just continue to ignore it and keep doing the right thing. That's the only thing that I can do.
So many people don't know Martin Walker, Nevada Veterans Association. So many people don't also understand that many judges are either the supervisors or managers of their staff. So how would your staff members describe the culture you've created and the climate of how you manage your operations behind the scenes?
We are a group. I don't view myself as the boss or anything like that. We are a group. We all help each other and we all work together. So, well, except for my JEA, Tracy Rawlinson, she's the boss. But aside from her, I think that, well, I know I've heard them speaking when they didn't realize I was listening. We have an open culture. We have an open chambers. We come and speak to each other. There are no stupid questions at all. And we all work together. I have a staff that works with me, that help me. They actually, they don't just sit there and support me in the sense that they don't just sit there and wait for me to give them direction. They know what they're doing and they would give me direction at times. We work together. We learn together. We grow together. It's a family. It's a community. I think with the exception of my marshal, who has changed because my last marshal got married and moved to Washington. We've all been together this entire time and we will all stay together. We all truly respect each other. We rely on each other. We lean on each other. And I think that they all agree that it's open, it's comfortable, and I don't want to say it's no holds barred, because obviously there are some holds that are barred in our department, but we're just there for each other. And like I said, never a stupid question. Except for sometimes I ask stupid questions, but you know.
Well, I'm almost out of questions, so I'm going to improvise a few things here.
Great, let's do it. The other guy's not here, so let's do it.
Jeff Lustig, Veterans and Politics International. Here in Clark County, judges routinely remand defendants into the Clark County Detention Center, either as a pretrial measure or on their way to the prison if they get a prison sentence. Now, this facility has faced repeated scrutiny for overcrowding, prolonged intake and release delays, and sometimes inadequate mental health staffing, and even in-custody deaths have occurred, including among veterans and medically fragile defendants. When you issue a sentence or an order of remand or set a bail or deny a release, what specific case-level considerations do you take into account regarding conditions at the Clark County Detention Center, and at what point does continued detention in that environment become ethically incompatible with your duty to uphold due process and human dignity under the Nevada Code of Judicial Conduct?
You just came up with it on your own?
Yeah, that's right. Winging it.
Wow. So when it comes to conditions for release, in 2020, the Nevada Supreme Court came out with the case Valdez-Jimenez versus the 8th Judicial District Court. And I wouldn't say that it created anything new. I mean, we have a statute on release conditions. It's 178 something, something, something. So, I mean, look, it's the presumption is that people are allowed to be out of custody pending trial. And so you have to operate under that presumption. So if the state is seeking some kind of conditions or remand, I have to listen to what they're asking for, because the burden is on the state to make that request. It used to be it was the burden on the defense, but Valdez-Jimenez definitely clarified that the burden is on the state to make that showing that someone needs to have some form of conditions on release. So if there are conditions that seem appropriate, then, you know, depending what they are, but I don't take finances into consideration, because finances mean nothing. I mean, you can be someone who, well, I mean, look, I'll never forget this. When I was a defense attorney, there was a case where it was a visitor to Nevada who was driving one of those like super ridiculous vehicles, drove 125 miles per hour and killed someone. And that person was able to stay out of custody because they had the financial background. Meanwhile, a person had no record, was there on some kind of theft-related offense, but because they didn't have money, they were stuck in custody the duration of their case. And that affected me because neither of those were my cases. I was just watching them in court one day. And why are we treating people differently because they have money? So money is not necessarily a consideration, except for someone who has a lot of money, and I want to make sure that they return to court. And sometimes money is where it hurts the most. And that's what sometimes priorities take a backseat to money. So if it's someone that has that backing, that's fine. But we have pretrial, what is it called? Pretrial PCU. It's a supervision unit. I'm sorry, I'm blanking on what that stands for. But we have this release facility that is really based on science too, and statistics, where you can have someone released and they're given reminders of when they have to come to court. And I like those kind of programs. They have to check in, things of that nature. Sometimes it's just spontaneous check-in right now type situations. But so long as someone is being supervised, if they need the supervision, I'll let them stay out of custody. Also, if there are people that are been in custody and they are not receiving the medical treatment that they need, they're not receiving the mental health treatment that they need, because CCDC is not providing it. And if they can prove that they have the abilities when out because they have community support, whether it's parents, siblings, spouse, something like that, someone like that, who will ensure that not only they come back to court, but then treat their medical requirements, I will consider releasing that person as well.
I'm going to wing it. We'll see.
Is it going to be like that one?
I don't know. Let's find out. As we continue to progress into our country's history, things are turning more and more political, and you're seeing judges make decisions based on their politics. Whether you're talking about a healthcare CEO getting murdered in New York, or you're talking about immigration reform and deciding who should be able to sneak out the back, or if ICE should have jurisdiction. And while you're not federal, I remember when I was growing up, judiciary was always explicitly nonpartisan. And now as we get into further and further along this path, we're always considering who appointed which federal judge, or, what state they're in and how they're ruling on this. And rather than giving you the softball question where you could say, I'm going to do it right according to the law, as a judge yourself, how do you feel about the public's perception of the judiciary now as it becomes more political and people are constantly considering the political affiliation of judges when it was always supposed to strictly be constitutional and the mandates, outlined by law?
It's unfortunate, and I think it's been around forever in the sense that people don't necessarily know who their judges are. Look, how many times has someone come to you saying, I have no idea who these people are, who should I vote for? So our job as judges is to be public so that we can get out in front of everyone and let everyone know who we are, what we stand for, and not stand for politically, but I stand for justice. I stand for equality. I stand for fairness. I stand for equal access, regardless of who you are, where you come from, whether you're represented by someone or not. So as far as, gaining the trust of society, aside from the folks that I spoke about earlier, where people are allowed to speak when they don't even know what they're talking about, I try to get out there to the public. I go to community events all of the time. I don't know how many things I've dragged my kid to because I want the people to know who I am as an individual so that I can earn their respect as a judge. And again, when I'm saying so they know who I am, I don't talk about like going to political events, like dogs in the park events, things of that nature. I want to meet people because I want people to know who I am so they know that I am someone that they can trust.
You took the softball route. How do you feel about your colleagues, or as the national view of the judiciary becoming more partisan?
I think it always has been, though. I guess that's part of it.
Better.
Yeah. No, look at the advent of the internet and social media. Things are out there that we never knew existed before. Didn't mean it didn't exist. What was it? I was listening to something where if social media had been around when Elvis was alive, then people probably wouldn't have thought the same about him as they do now. It's always been political. It's always been partisan. We just didn't know it. You can even look at some of the decisions that have previously been made, and you can look at the opinions from the Supreme Court and figure out the political maneuverings that were used and decided in order to make their decision. So politics has always been around. It's just we didn't know it.
Thank you very much.
Thank you very much. Judge, would you give us a 30-second closing statement?
First, I want to thank you all for allowing me to be here today. This has been a pleasure. I was very nervous, to let you know, before I got in here. Look, I love being the judge in Department 17. I love being your judge in Department 17. My life has been based on civil service. My husband is a retired police officer. My family, we live through honor and justice and fairness. And I know that as I continue to be your Department 17 judge for the next 6+ years, I will continue to earn your respect, and I promise to treat everyone with respect as well.
Thank you very much. This is the Joint Veterans Endorsement Interviews for Judicial Candidates, sponsored by Veterans in Politics International, Nevada Veterans Association, Armed Forces Chamber, Judge Jacob Reynolds, Department 29, and Judge Mary Perry in Department P. We'd like to thank you for watching and listening.